Good morning, members. It is time to start the meeting. We have also formed a quorum. I would like to thank everybody for supporting the Bills Committee's work, and let me wish you all a happy new year and good health. Let's hope that we can finish the work in time, and let's invite the administration's team to join us. I think you have already received papers from the administration. There are 2 sets of minutes. We haven't received any proposed amendments. So members, if you do not object, I assume that you can endorse the minutes. And so minutes confirmed for the 2 meetings held previously. In attendance today, we have the following public officers: Ms. Ada Chen, PS for Financial Services and the Treasury. We have also got colleagues from the Department of Justice, the Hong Kong Monetary Authority, as well as the Securities and Futures Commission. I don't intend to read out the names on the list one by one, as everybody has already got a copy of the name list of public officers in attendance. At previous meetings, the administration has indicated that in relation to Part 3, there will be CSAs from the administration. So the Bills Committee has agreed to take the clauses under Part 3 together with the CSAs to Part 3. In other words, clauses 56 to 60 plus the CSAs proposed. Our legal advisor on the 11th of February 2014 wrote to the administration raising certain questions. The administration has come back with a reply. You find it in paper CB bracket 1 874/13 to 14/02. I would like to give the floor to Ms. Chen to walk us through the paper. Ms. Chen. Thank you, Mr. Chairman. We have completed the cross-scrutiny for the majority of the clauses except Part 3 protections. In other words, clauses 56 to 60. Soon after the Bills Committee was set up, the Hong Kong X provided a written submission suggesting certain amendments. We have indicated that we would follow up on the proposed amendments from the Hong Kong X. We liaised with them afterwards, and we had an exchange of views, in the course of which they provided further suggestions. In the paper from us on the CSAs, we have already identified those amendments proposed in response to the Hong Kong X suggestions. So I would like to say that we are most grateful to the legal advisor for writing to us on the 11th of February so that we can elaborate on the rationale. We have provided a paper, so I would like to brief you on the paper. Well, for the existing Section 40 of the SFO, it provides that for a recognized clearing house, if there is a clearing participant that is a clearing member of a RCH default, then we've only got rules for the default of such cases. And the amendments seek to extend the scope of the default rules of an RCH and thereby the coverage of the insolvency override protections under Part 3 of the SFO, so that they also apply to A, defaults of the RCH itself, and B, certain client clearing arrangements for over-the-counter derivative transactions supported by the RCH. It was a long time ago that we had our previous meeting. At earlier meetings, I've already said that RCH and other specified organizations, in relation to certain rules, they have to name certain OTC. Such transactions could have been directly via the CCP or indirectly a third party be transacted. for indirect clearing through the CCP, it means that either the members or clients of the members may do so indirectly. Our law would say that it is a mandatory requirement that clients must do so via CCP in relation to certain OTC transactions. Therefore, we believe that there must be adequate investor protection to support the activities. Therefore, the amendments here are mainly to make sure that for those indirectly making use of RCH services, the positions and the collateral under its name can be separated and can be moved, so that to make sure that investors making use of recognized clearing houses, they will get better protection. Such a protection is most important. Say, for example, a clearing participant or a clearing house become default, then or insolvent, then it is hoped that the positions and the collateral can be returned to the investor more effectively, or ported in accordance with the instructions, so that the liquidation process will not be easily paid to other creditors. The details have already been set out in the paper. We have already acted in accordance with the law, that is, or acted in accordance with the request of your legal advice. We have tried to make use of the case of a typical client to illustrate the point. There's also one other amendment. It is proposed that the scope of the protection of the insolvency override protections, we can also cover actions following a default of the RCH itself. This is in line with the international trend. The CPSSIOSCO principles for financial market infrastructure also request that such a protection is needed and legal certainty is desired. Therefore, we have the new section 40 bracket 2A, so as to cover all the CCP. I'm going to give the floor to the SFC colleagues to brief you on the clauses 56 to 60 under Part 3, and they would also, at the same time, talk about the English version of the CSAs. We are sorry that for the time being we are not able to provide the Chinese version of the CSA, so we will adhere to the English version for the time being. Who from the SFC? Mr. Leung. I'm going to talk about Part 3. Ms. Chen gave you a brief word. Well, for the amendments under Part 3, would like to provide changes in two areas. First of all, for the OTC transactions, we require the CCP or clearing house to be made use of in the activities. In the course of it, many clients may be working through clearing intermediaries for the purpose of clearing. If there is a problem with the intermediary, or there is a default either for the intermediary or default for the RCH, we would like to provide better protection. So part of the amendments is to make sure that the insolvency override protections can be extended to the clearing of the clients. And then international organizations are also very concerned about the solvency of the clearing houses. So CPSS and IOSO has also come up with new requirements. If the clearing house itself is in default and it cannot meet with the requirements of its members, then we would like to know what to do with the positions that have not yet been closed. So there are certain requirements here to provide for the default of the clearing house itself, so as to provide some protection. Just now, it is said that under Part 3, the amendments will be such that after we have submitted the bill to you, the Hong Kong X has come up with many suggestions. We've talked to you, and therefore we have come up with certain revisions, quite a lot of them, as we think that their suggestions are good. So I would like to, based on the CSAs as the text for our briefing. I'm sorry that we have only got the English version, so I will be speaking in English. Otherwise, it will not be smooth if I switch between English and Chinese, and I haven't got the Chinese terms for the English version. So I would like to adhere to the English version of CSA.
The CSA version to brief members on the proposed change set out in the Part 3 of the SFO. Firstly, it's about the clause 57. In the CSA version, please refer to page 96. Okay. Clause 57 amends Section 18 of the SFO. Section 18 is about the interpretation of Part 3, i.e. Under Section 18, we define several terms used in the Part 3. Clause 57, the subclause 1, expand the definition of default rules to cover the rules made by the clearinghouse under the new Section 42A. I will talk about the new Section 42A later. But basically, the existing Section 40 only provides the clearinghouse to make rules in the event that its clearing participants are in default. But the new Section 42A expands the scope of the default rules to cover the situation where the clearinghouse can make its own default rule to deal with its own default situation. Say, for example, if a clearinghouse does not have sufficient financial resources to deal with a member default, then the clearinghouse will become insolvent. So under the new sections, the clearinghouse can make rules to set out what they will do in the event of its own default. So by expanding the definition of the default rules to cover the default rules made by the clearinghouse in relation to its own default, we can provide sufficient legal backing to ensure that the action taken by the clearinghouse in the event of its own default will not be challenged by the liquidators. So basically, the subclause 1 is explain the definition of the default rules. Subclause 1A amends the definition of the defaulter to include not only the clearing participant, but also the clearinghouse itself. So basically, after the amendments, the definition of defaulter will include the default of a clearinghouse, the recognized clearinghouse, if the clearinghouse has already made rules to govern its own default. So this amendment is consistent with the new Section 42A regarding the default rule made by the clearinghouse to cover its own default. If there is no questions, then I will go to subclause 2. Subclause 2 includes a new Section 18.7. As you can see on page 96, in A, the subclause 18.7 aims to clarify what is market collateral. And in A, as you can see, the market collateral basically is divided to include properties held or deposit as collateral, margin or guarantee fund contribution. So this amendment attempts to clarify what is the market collateral, and as a result, the clearinghouse could be protected in the event of the default by the clearing participant. Page 97, in B, we further define or expand what is the guarantee fund contribution. As members may be aware, a clearinghouse usually establishes a guarantee fund to cover the default arising from its clearing participant. So the guarantee fund is mainly made up by the contribution by the clearinghouse itself and by all the clearing participants. So in other words, in the event of a default by a clearing participant, the clearinghouse can use the guarantee fund to cover the loss arising from the default. And we consider one scenario, for example, when a clearing participant is in default. So under the rules of the recognized clearinghouse, the clearinghouse will first use the guarantee fund contribution provided by the defaulter to settle the loss. There may be legal uncertainty because if the guarantee fund contribution is not define under the SFO as a market collateral, then we are concerned about whether there may be legal uncertainty regarding the guarantee fund could be available to the clearinghouse to handle the default situation. For example, in the event of a default by a clearing participant, the creditors of the clearing participant may ask the clearinghouse to return the guarantee fund contributed by the defaulter to offset its debt or to pay its debt. So by making clear that the default fund contribution is part of the market collateral, we can provide legal certainty to the clearinghouse such that they can always use the guarantee fund to cover a default situation. So basically, in B we define what is the guarantee fund. And if members do not have comments, then I will move to page 98. The Clause 50H also proposed to amend the section 40 by including a new section 42A. As I mentioned earlier, the 42A, as you can see in Part A, we proposed to include new sections to enable the clearinghouse to make rules for taking proceedings or other actions to deal with its own default. So in other words, in the event of a clearinghouse failure, then the clearinghouse will, based on what mentioned in its rules, to deal with the outstanding position held by the clearing participant. So by including the clearinghouse default rules in these new sections, we can give legal certainty to the enforceability of the recognized clearinghouse rules in the event of its own default. So we can ensure that the action taken by the clearinghouse in the event of its own default will have the legal finality. So it will not be challenged by the liquidator or will be challenged by the law of the insolvency in Hong Kong. Okay. In the Section B and C, i.e. page 99 and page 100, we propose to add two subsections to provide a new arrangement which is now being proposed by the international setting bodies. As we mentioned at the beginning, under the new CPSSIO school standard, there is a requirement that a clearinghouse should establish a portability arrangement to protect the interests of the customer. Under the portability arrangement, in the event of a default by a clearing participant, the kind of the defaulting clearing participant will be allowed to port, or in other words, to transfer their position or related collateral to other clearing participants. So in other words, in the event of a default, then the client will not need to wait until the completion of the liquidation process before they can get back their money. So under the portability arrangement, in the event of a default, client can transfer their position from the defaulter to other clearing participants to continue their contracts. So this portability arrangement is aimed to protect the interests of the investor or the customer. So in the subsection B and C, we set out that the clearinghouse can make rules to support the portability arrangement. So basically, B is talking about a client of the clearing participant can transfer their position to other clearing participants. And C covers the situation where the client can also transfer the related collateral to other clearing participants in the event of a default.
Any question? No. Okay, go ahead.
Okay. Then please turn to page 100. And 100, as you can see, the sub-clause 2, we propose to add a new sections to define what is client account and what is house account. And basically, this amendment is consequential to the amendment to this section 42A because the term client account and house accounts are used in these sections. So basically, we define what is client account and house account. Okay.
We go to 101 page.
Okay. Page 101, the clause 58A, we propose to add the provision of market collateral as in these sections. Basically, because at the moment the clearinghouse receives collateral from the market participant to cover their positions. The collateral can be provided in different forms. Some market participants provide the collateral in a long cash form. Some will provide the collateral in cash. So this amendment is in response to the comments from the Hong Kong exchanges, because they believe that by including the term provision of market collateral, we can make sure that the market collateral definition can include those collateral which are transferred to the clearinghouse as an outright transfer. So in other words, if a clearing participant transfers the cash to the clearinghouse, then by having these new sections, we can ensure that the cash collateral is covered under the insolvency override protection. So this is mainly a technical amendment.
Okay. No question? We will go to page 102.
Okay. Page 102 is a minor amendment. We propose to replace the term the net sum, if any, by any net sum. So it's, I think the amendment is straightforward and the language is better.
Okay.
Okay.
Then cost 60.
I would like to talk about the cost 60, page 103. Page 103, the cost 60 adds two new sections, Section 2 and Section 3, in Part 5 of Schedule 3 of the SFO. Part 5 of Schedule 3 in the SFO is mainly set out the requirement for the default rules to be made by a recognized clearinghouse. In the new Section 2, basically, we want to include a arrangement under the clearinghouse so that we can better protect the customer. As you can see in the Section 2 and 3, under these two new sections, what we try to achieve is that in the event of a default by a clearing participant, when the clearinghouse calculates the net sums payable by the defaulting participant to the clearinghouse or vice versa, the calculation should be done separately in respect of the client account and house account. So under default situation, the clearinghouse could not or not allowed to calculate the amount payable by or payable to the clearing participant for both the client account and house account together. They need to do a calculation separately. And if you look at Section 3B, i.e. page 105, you will have more information about why we need to have a separate calculation. On page 105, Section 3, we clarify that in the event of the default, any net sum payable to the clearinghouse in relation to its client account must not be set off against any net sum payable by the clearing participant in relation to its house account. So in other words, in the event of the default, if there is surplus fund available in the client account, the surplus fund must not be allowed to offset any losses arising from the house account. So that means the client interest should be protected in the event of a default. If there is any surplus fund available in the client account, the surplus should be retained and returned to the client.
Okay.
I just want to know if there is any regulation which requires the participant to keep separate client accounts within the so-called client account label if it got, several thousands of clients. Do they need to keep omnibus client account within the client account itself?
Thank you for the questions. I think there are basically two levels of the requirements in relation to the client account segregation. Firstly, under the SFO, we have a client money rules which requires our licensed corporation to segregate the client's money so that they cannot commingle both the client monies and the house money in one single account. So, i.e., under the SFO requirement, they need to segregate the client's money in a segregated bank account. So the second level is about the requirement under the CCP, under the clearinghouse. Most of the clearinghouse now have established different client structure to facilitate the clearing participant, i.e. the brokers, to segregate the client position as well as the client collateral. There are different arrangements. The most common arrangement is that the clearinghouse simply create an omnibus client account, such that all the client assets will be maintained by the clearing participant with the clearinghouse in the same account. But I think over the past several years, there is a trend that more and more clearinghouse now provide individual client account to the brokers. So in other words, if a client requests and the brokers decided to entertain the request from the customer, then the brokers can open individual client account at the clearinghouse for each of the clients. So the advantage, of course, is that in the event of the default, the client asset of that particular client could be easily identifiable.
Okay. Okay. So, yeah.
Thank you for your response. And my understanding is that what you have told us and in this committee is that there's a requirement for the client to segregate, or the broker or the participant to segregate client position and client collateral, right? In two separate accounts. That is the basic requirement. My question is there any rules which regulate the hypothecation, meaning the use of client collateral, in particular in relation to these OTC derivatives? Are there special kinds of rules, or are we sticking to the normal rules? Or if there are the normal rules, what are those normal rules in relation to hypothecation of clients' collateral? Are the participants allowed to use the collateral in other ways other than just, putting them or sitting them in the client collateral account? That's my question.
Okay.
Thank you for the question. At the moment, we haven't developed the details requirement for the client segregation in relation to the OTC new regulations. As we mentioned earlier in the previous meeting, after this bill is approved by the LegCo, we will also make subsidiary legislations, or we may also need to amend the existing subsidiary legislations to reflect the new requirement under the OTC regulatory regime. So we are still in the process of discussing internally how to set out the requirement in the subsidiary legislation. So one possibility is that we may amend the existing sublet to include a new requirement for the kind asset protections in relation to the OTC market. But a quick response to your question is that I think in most of the jurisdictions, the collateral provided by clients to cover the client's own position could not be used by the brokers for any other purposes. So the brokers can only use the collateral to offset or to cover the potential loss arising from the position held by the customer.
But my understanding is that there are quite a number of industry-wide standard contractual templates which do allow the collaterals to be used in other ways. Are you saying that the future direction of the subsidiary legislation will be to prohibit such other use? Is my question clear?
Yeah. Rico.
Yeah, I think at this moment we haven't have a concrete idea how to do it, because in relation to the OTC market, the development is evolving. Say for example, we understand in some jurisdictions the brokers allow the client to provide collateral which are not of good quality. But as you know, the CCP, the clearinghouse, also need to accept collateral from the brokers. So the CCP, in order to protect itself, the CCP has set out very stringent requirement to determine which particular collateral could be used by the brokers to cover their positions. So because the brokers accept the low quality collateral from client, but on the other hand, the CCP only accept high quality collateral. So there are some new services developed by the brokers to help the brokers to channel the low quality collateral to become a high quality collateral to meet the requirement by the CCP. So there are many new developments. So I think at this moment we I'm afraid that I cannot tell you all the requirements in detail, but in our subsidiary legislation process, we will of course set out all the requirements, and the subsidiary legislation will also be provided to the electrical for negative rating.
Okay. Okay. Yeah. Then we go ahead. Okay.
Okay. Then I would like to talk about section 3C. In C, we basically clarify that if there is a surplus fund available in the house account of a defaulting curing participant, then the surplus fund available in the house account can be used to offset the loss arising from the client account. So this is an arrangement to ensure that if the booker is in default, its own money can also be used to cover the loss arising from the client account. Indeed, in the subsection 3D, this is a new section we include in response to the comments from the Hong Kong exchanges. As I respond to the question from Mr. Kenneth Learn earlier, in some jurisdictions, the CCP have allowed brokers to open more than one client account to better protect the interests of the customer. So the new section 3D is include to clarify that if the rules of a recognized clearinghouse allow a clearing participant to open more than one client account, then set off among different client account is not allowed. So that means we want to ensure that if the position are maintained in separate account, then that position could not be used to cover or to offset the losses arising from the position held by other customer.
Okay.
Okay. Then I would like to talk about page 106. Page 106, there are two new subsections, A and B. In A, we basically want to clarify that the portability arrangement, i.e. in the event of a default, then the client can transfer the position from the defaulter to other clearing participant. So we want to clarify under A that the portability arrangement for the outstanding contract in the client account is regarded as settlement of the contract for the purpose of Section 1A in Part 5. So in other words, if a contract of a client is transferred or ported to, from the defaulting clearing participant to another clearing participant, then the contract will be regarded as settled contract under A. And in B, we further clarify that the rights and the liabilities of the clearing participant should include the rights and the liability arising from the portability arrangement. So A and B are just mainly for clarification purposes. Okay. If members do not have questions, then I will talk about the new Section 5. Section 5 clarifies that the Section 1, 2, 3, and 4 in this part applies despite Section 55 of this audience. Because in Section 55, we expanded that for the contract between a recognized clearinghouse and a clearing participant, the clearing participant is to be regarded as entering the contract as a principal. Because in these sections we talk about the client account and the house account, so we want to make sure that even though the clearing participant is regarded as a principal from the clearinghouse perspective, when we calculate the profit and loss in the event of the default, we also need to separate the calculation between client account and the house account. Okay, if no questions, then I will want to talk about the new Section 5A. The new Section 5A simply clarify that the term set off or offset used in the audience include the netting arrangement. This change is in response to the comments from the exchanges, because the exchange believe that the current term of net off or offset may not be clear enough whether these two terms could cover the netting arrangement in the event of the default. So we discussed with the exchange and agreed that to provide legal certainty, it would be better to have the new sections to clarify that set-off and offset also includes a netting arrangement.
Okay, Kenneth.
I think the set-off concept and the netting are two totally different concepts, right? You recognize that, right?
Yeah.
Set-off is where you set off a surplus and a deficit. And the netting is only when you consider the end result of a position and you do a netting, which also arises in a situation of liquidation. So I'm not too sure what's the direction of your amendment. Either you are clarifying the term, or you are saying that set-off is a kind of a netting. Am I right in saying that, or what is exactly the rationale or the mischief of your amendment?
Okay. Echo.
Maybe I ask my colleagues to provide further information.
Okay. Ms. Mukadam.
Yeah. Thank you, Mr. Leung, for the question. The idea really is that in Schedule 3, the language used there sometimes talks about settling an obligation or talks about set-off or offsetting. And the purpose of the amendment is to make sure, because in some jurisdictions they don't do set-off, they do netting. And the idea is to make sure that when we talk about the calculations for the purposes of the Section 3 provisions, we want to include both types of arrangements, both the set-off arrangements and the netting arrangements. As we understand it, for set-off, what you have is two debt obligations already existing. And in a netting arrangement, that's not yet there. The actual debt obligation does not arise until you come to the final netted figure. So therefore, the two concepts are very different. But because the existing SFO language uses set-off, we want to make it clear that just because we're using it, we're not actually restricting it to that type of calculation. We're also allowing for netting arrangements to be taken into account.
Okay, fine.
Okay. Yeah, it's clear. Okay.
If no further questions, then I will talk about the changes on page 107. 107, the new section 5B, also wants to clarify that the reference to a sum of the money payable by or payable to a person should include the value to be taken into account when the netting arrangement takes place. So this is a very similar clarification to the earlier sections. In the next section, section 6, we include different terms to define, to give a different definition of various terminology we use in the sections. The definition include client account, house account, and netting, as well as the recognized clearinghouse rules. I think these definitions are quite straightforward, so I would not go through all the definition one by one. Basically, the client account and the house account definition are similar to the definition I explained earlier. And on page 108, you can see the legal definition of netting. And we also include a definition of the recognized clearinghouse. Basically, the recognized clearinghouse rules are those rules made by the clearinghouse referred to in section 1. So these are all the definition issues.
Okay. Any questions from members? 如果大家同事冇
If you don't have other questions, then we can continue and we can move on to another paper. Ms. Chen? Yes, the next paper is in relation to the question asked by the Bills Committee. At previous meetings, we have come up with a reply. I would like to highlight a few points. First of all, for Section 101V, a member asked this question. For Section 101V3, how is it different from the other subsections? Well, if a system important participants do not comply with the requirement, then the court may ask for compliance and have a punishment. Members asked why there is a difference in relation to the treatment. This is because in accordance with 105, in relation to Section 185, we have come up with this idea, 1851B, and you can refer to Annex A in relation to the case. From the CFI's judgment, you can see that if somebody doesn't follow the court order, in the case of non-compliance, the court may exercise discretion to punish this person. And then it is not just about compliance with the order. There may also be a punishment in relation to the contempt of court. So we'll come up with a court case to illustrate the point. And then members also asked about the rights and protections afforded to persons under investigation and past experience. Members asked about the following. Say, for example, in an investigation conducted by the SFC to assist an overseas regulator, a notice to produce records or documents issued to a PUI or a person providing assistance, whether it will include the identity of the overseas regulator, reasons for investigation, relevant overseas legislation, and equivalent type of misconduct provisions under the SFO. We confirm that such information will be included in Annex B. We have given a sample notice. In the paper, we have also set out the following. Under the SFO, we do have provisions to make sure that the PUI has certain rights and protections. The provisions are all set out in our paper. And then, for the cooperation or assistance, mutual assistance between our SFC, our regulators, and other regulators, further information has been asked for. In particular, the list of the IOSCO Memorandum of Understanding. We have already set out the information in the Annex D, and Annex C rather. And then we have been asked as to the MOUs signed and other agreements. We are asked to provide a list of regulators involved. You'll find the information in Annex D. Members also asked another question. Under the SFO, there is this $10 million cap. We were asked to give the rationale for this figure. When we drafted the SFO, we had made reference to the practices in similar jurisdictions to come up with the cap of $10 billion. You find the information in the consultation document on the Securities and Futures Bill published in April 2000. We compared the cases in the US and the UK. Relevant information can be found in the paper. And then a word about protection of personal data privacy. In our paper, in response to members' requests, we have confirmed the following. That is, the requirements will be complied with by the Hong Kong TR. Internationally, the Committee on Payment and Settlement Systems has also come up with a number of documents. The International Swaps and Derivatives Associations have also developed various protocols to facilitate market participants in amending the relevant agreements so as to comply with the requirements. The information has been clearly set out in the paper. Lastly, at your last meeting, you did ask us as to whether Schedule 11 can be amended so as to bring the Section 33(4) of the Chinese text be more readable. We have already proposed a CSA so that it can be simplified. Currently, we've only got the English version, but I can assure you that there will be corresponding changes to the Chinese text. Members, any questions? If members do not have questions, then we have finished with this paper. Well, for the other CSAs, I think you have already got a copy. So, Ms. Chen, do you have anything special to bring up with us? For the CSAs, well, most of them have been sort of introduced in response to the Hong Kong Act's submission to members, as well as further suggestions from the Hong Kong Act. The majority of them have already been explained by Mr. Leung from the SFC. And then another main group of CSAs is as follows. We have this responsibility of reporting and record keeping, and the relevant penalties, we can give an explanation. For other revisions, they have been proposed in response to the market participants or for the purpose of making it more readable or clarifying the positions. All right, members, do you have any questions? No? No questions? Mr. Ng Sing. In relation to the record-keeping obligation, I want to know whether it will add to the cost of the operators. And I want to know whether there are any standards or benchmarks for them to follow so as to discharge the record-keeping obligation. And I want to know whether they are consistent across the board. But of course, I'm more concerned about the case of the implications on the costs and the fees. For the record-keeping obligation, this is to supplement what we have already got in the bill. There's the reporting, clearing, and trading obligations. This is to prove whether the relevant participants have already discharged their mandatory obligations. So record keeping is in fact already provided for under the SFO. For OTC derivatives, internationally speaking, this is always the practice. Our understanding is that in the USA and in Europe, they have similar requirements. The details will be set out in the regulations. We will have further consultations on that. In fact, the market has been consulted, like the HCAP, and in principle, there is no objection to the introduction of this obligation, but they would want to know more about the details. Maybe the SFC can also supplement. Mr. Chiang? Oh, Ms. Chiang. Thank you. Thank you, Mr. Ng, for your question. As Ms. Chen has already said, we have already started our initial consultation with the market, the HCAP, as well as other stakeholders. Basically, for the obligation introduced, they don't have a strong voice of objection. Mr. Ng referred to the concern about the cost implication as well as the details. Well, at the level of the regulations, there will be further and more detailed consultation. This requirement is basically in line with the regulatory requirements in the US and Europe. My understanding is that the majority of the market participants have already noted these obligations, and some of them have already started to honor the obligation. We'll make sure that we are not exceeding the requirements elsewhere. So I think we'll continue to keep up a dialogue with the market participants. All right. In other words, more or less the same as the so-called the other electronic systems in terms of this levy. This is something different. When you have to go into the OTC derivative trading, you need to sign agreements. And for the transaction itself, you need to confirm the information. So the documents related to such activities have to be kept. In other words, we aren't asking for a separate system to keep the records. Is it clear? All right, members. Do you have other questions? No? Well, in this case, basically, we have already completed the cross-by-cross scrutiny of the bill. So, administration, when do you intend to come back for the resumption of the second reading debate? We need to supply the Chinese text of the CSAs. We'd like to resume the second reading debate ASAP. Probably the earliest time will be April. Yes, that would be good. Well, members, I suggest that once the administration has come back with the Chinese text of the CSAs, I will forward them to the legal aid to have a look, to check whether the rendition, the drafting are fine, and then members can always raise questions if necessary. If we haven't got anything major to discuss, then I won't call another meeting. But then if necessary, if you think that certain things in the CSAs should be tidied up, you can propose to the Secretariat, or we can have a meeting to deal with them. But for the time being, I won't be arranging for another meeting. So we just bear in mind that in April they will come back to the LegCo so as to resume the second reading debate. All right? Well, in this case, the Secretariat and administration will try to agree on the timetable. If you want to move CSAs, please bear in mind our timetable. For the time being, I don't think I can report to the HC yet. I have to await the date to be given by the administration. All right, if you haven't got other questions, that's it for today. Thank you. Thank you for attendance. And I would like to thank the SFC, the Hong Kong MA, for your assistance. Thank you.